Welcome to the new episode of Bharatiya Nyaya Sanhita 2020-23. Today we continue with the discussions regarding definitions such as movable property, number, oath, etc. Movable property, section 2, subsection 21 of the Bharatiya Nyaya Sanhita. Movable property includes property of every description except land and things attached to the earth or permanently fastened to anything which is attached to the earth. The corresponding provision is section 22 of the Indian Penal Code. Section 22 of the Indian Penal Code, movable property. The words movable property are intended to include corporeal property of every description except land and things attached to the earth or permanently fastened to anything which is attached to the earth. Section 2, subsection 21 of the Bharatiya Nyaya Sanhita says about movable property. The corresponding provision is section 22 of the Indian Penal Code. What is meant by movable property? In order to understand the meaning of movable property, we should understand what is meant by property. Property are of two types. One is immovable property and the other one is movable property. Movable property means, as per the definition, anything which is attached to earth and permanently fastened to it, land, and all other things are movable properties. In other words, things which can be moved from one place to another is a movable property. For example, these specs, it is a movable property. This can be moved from one place to another. That is known as movable property. Then the corresponding is immovable property. Immovable property means that cannot be moved from one place to another. For example, land or building or something which is attached to that building. All these are immovable properties. So, if a building is constructed in a land, then that building become part of immovable property and not movable property. And a fan, actually fan is a movable property. We can purchase a fan from the ceiling fan from the shop. But if we purchase a fan and if we fasten it to that building permanently, then that fan become immovable property. So a ceiling fan, while it is purchased from the shop, it is movable and we can take it in a box or in a bag or in a packet. But very same ceiling fan, when we attach or fasten permanently to that building, it will become part of immovable property. Likewise, a tree standing on a land is immovable, a coconut tree or a rosewood tree or a teak, that is immovable. The very same teak or rosewood, when we cut and remove it, and if that wood is taken to a mill, sewing mill, and cut into pieces so as to make furnitures, the very same wood when cut will become movable property. Finally, it will become a furniture like settee, sofa or dining table or chair. Then that dining table or chair will become movable property. So once upon a time, wood was part of immovable property. Then when that tree is cut, it becomes movable property. Finally, become finished good like a furniture or a table or a chair. So this is the change of things. And in the modern scenario, there is yet another type of property, that is intelligible property. This movable property and immovable property that we can see, we can touch, we can sense by our senses. We can take hold of it. Likewise, I can sense it, I can hold it. It's tangible. There are certain properties which are intangible, which means we cannot touch it, but we can sense by our intellect. That is known as intellectual property. Copyright, patent right. These are the trademark rights. Then intellectual properties like industrial design. All these are intellectual properties, but we cannot see it, we can sense it, and we can sell it as a property. It is valuable, we can transfer it, we can sell it, we can collect money or value out of it. It can be transferred to someone else. So that is known as intellectual property, which is intangible. So movable property and immovable property are tangible properties, but whereas the intellectual properties are intangible properties. These are the main difference between the properties that a student of law or a ordinary man or a lawyer must keep in mind about these the difference among the property. The next one is number. That is defined in section 2 of Bharatiya Nyaya Sanhita in subsection 22. Number, unless the contrary appears from the context. Words importing the singular number includes the plural number, and words importing the plural number include the singular number. The corresponding section is section 9 of the Indian Penal Code. Number, unless the contrary appears from the context. Words importing the singular number include the plural number, and the words importing the plural number include the singular number. Section 2, subsection 22 of the Bharatiya Nyaya Sanhita and section 9 of the Indian Penal Code say about number. Normally we see number means 1, 2, 3 alphabetical numbers or numerical numbers. Things A, B, C, D we can say like that, or we can even A, B, C, D can be numbering, or numbering can be 1, 2, 3, 4 digital numbers. That numbering also again can be Roman numbers or Arabian number. Roman number is something else, numbering is different. Arabian numbering is 1, 2, 3 normally that we use. In Malayalam or vernacular language also, in Hindi also we have different type of numbering. That we understand. But in law, a singular number includes plural. So if a word is used, a person is a singular number, but that includes a plural number, that is to say persons. So if in a statute, word person is used, that includes persons. And if that very same statute persons is used, then it can be a singular person also. This we use in a court of law. For example, a murder, an offense of murder is committed by more than one person. It can be committed by a single person also. So either a singular person can commit the offense of murder, or a group of persons can commit the offense of murder. So we use the term accused in the court of law. In the charge sheet, in the final report, the word accused is used. This accused can be singular or plural. Normally, while we are arguing in a court of law, the accused committed the offense. Then the judges would ask, what is your rank? So we would say, I am first accused, or second accused, or third accused, or things like that. Assume for a moment there is only one accused. Then we will submit the petitioner is the sole accused. Only one accused, that is we use the term sole accused. So the number singular includes plural and plural includes singular. So this variation a student of law must keep in mind while dealing with the cases or arguing in the case, or while defining things, or while reading the pleadings, or making pleadings like appeals or bail applications, etc. Next is oath. That is defined in section 2, subsection 23 of the Bharatiya Nyaya Sanhita. Oath includes a solemn affirmation substituted by law for an oath, and any declaration required or authorized by law to be made before a public servant, or to be used for the purpose of proof, whether in a court or not. The corresponding provision is section 51 of the Indian Penal Code. Oath. The word oath includes a solemn affirmation substituted by law for an oath, and any declaration required or authorized by law to be made before a public servant or to be used for the purpose of proof whether in a court of justice or not. Section 223 of the Bharatiya Nyaya Sanhita or Section 51 of the Indian Penal Code say about oath. Normally, oath is made or administered in a legal proceedings so as to make it solemn affirmation. Means a person is giving an undertaking in a court or legal proceedings that I am saying the truth and I am not telling lie. I intend to do what I say. It is not a joke. Normally in common parlance we say jokes, we share many other things, or some people may make gossiping, some people may tell lie. But in a legal proceedings, a person has to give a solemn affirmation that what I am saying here is truth. And normally in a court of law, this oath is taken in the name of God. So I do swear in the name of God that what I shall depose be truth, the whole truth and nothing but the truth. That is what the oath is taken in legal proceedings while giving evidence in a court of law as a witness, or somebody swearing in as the President of India or a minister or as a judge or as an advocate or things like that. So in the name of God, oath is taken. So the reason behind this is if somebody tells lie in the name of God, it will amount to blasphemy. So no one will be interested to say something blasphemous. So a believer of God will be in his God's name will say only the truth. That is the intention behind it. Up to that extent it is okay. Assume for a moment a person does not believe in God. What is to be done? An atheist. Why should he give an oath in the name of God? He is an atheist. Secondly, even those persons who believe in God, they don't want to take any risk. They don't want to swear in the name of a God. So because they may feel that something come against them from the God. So they don't want to misuse the name of God. So in such circumstances, so those who believe in God, those who do not believe in God, they can give solemn affirmation. Instead of taking an oath, in the name of, instead of oath, they may give a solemn affirmation. So in the statute, both are considered to be oath. Swearing in the name of God or taking solemn affirmation, both are considered to be oath in the eye of law. So all solemn affirmation include oath. So the word, it's an inclusive definition. So swearing in the name of God as well as taking solemn affirmation or giving declaration included in the term oath, which means if somebody violates or subsequently it is found to be not true, then prosecution can be initiated against that person for giving false evidence. So that is the reason behind giving evidence by oath. This need not be an evidence in a court of law alone as a deposition. It can be an affidavit, it can be a pleading, it can be a declaration also. So such type of evidence also considered to be oath. For example, an affidavit is given in a court of law. So at the end of an affidavit, normally the deponent would say, what all stated above are true and correct to the best of my knowledge, information and belief. So such an affirmation is made by a person who gives affidavit in a court of law or for any other authority. The definition says it can either be for a public servant, that too before a court, or somewhere else also. So merely because it is not given in a court of law, the person giving oath is not exempted. And subsequently, the affidavit also attested by an advocate or a judge or by a public servant or by a gazette officer. So those persons who are authorized to attest the affidavit also there. So normally in court proceedings we advocates attest. So solemnly affirm and sign before me by the deponent who is personally known to me or who has been introduced to me by someone else who is personally known to me on so and so date at my office at so and so place. So this type of attestation is given by the advocate or a gazetted officer or a judicial officer while attesting an affidavit. So this will be considered as an evidence. It's a substitute for evidence. So need not give evidence in a court of law if an affidavit is given. So then affidavit is a substitute for evidence. In all cases, it is considered to be oath under law, which means evidence, oral evidence in a court of law, or given to a public servant, or any pleading in the form of affidavit or undertaking given in the form of truth, that is also considered to be an oath in the eye of law. The consequence will be, if such an solemn affirmation is given or an oath is taken, then subsequent violation, or if it were found to be untrue subsequently, then prosecution will be initiated against the person. So while giving oath, all these persons, all these points are to be kept in mind. So the advocates or the public servants should give caution while attesting an affidavit, or a judge should give a caution to a person who gives evidence in a court of law that you are giving something as solemn truth or under oath, and if it were found subsequently this is not correct, you will be prosecuted or legal action will be taken against you. This session will be continued in the next episode. Kindly inform me your doubts or clarifications if any. This will be continued in the next episode.